Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we continue our video series designed to educate the public, so please subscribe to our channel. I want to talk about post-judgment matters. And by post-judgment matters, I mean that there has been a case, it has pended for a long period of time, the court has either gone to make a ruling as a result of a trial, or there is already a judgment, not because of a trial, but because of consent of the parties, and they arrived at a judgment. Either way, where we stand now, we're in the post-judgment phase of this case. It's like if you go to trial and you win, and the jury says you get $100,000. Now, we have an order that says we're entitled to something. Now the question is, how do we get it? Remember one thing. In a civil case, where maybe you're more familiar with those kind of things because you hear about them by TV lawyers, you know, you slip and fall or you hurt your neck in an auto case or something like that, and the insurance company pays you money or you get a judgment. You have to understand one thing. When the judge says you're entitled to a certain amount of money, he doesn't pull out a paycheck. He doesn't pull out a checkbook and write you a check. You don't get a paycheck from the court. The court doesn't do that. The court has mechanisms by which collections can occur, but the judge doesn't write you a check. Similarly, in a divorce, you may have a judgment that says you're entitled to the house, you're entitled to a certain level of support, you're entitled to have this account split, and you're supposed to get a check written from that account to you. How do you get it, though? Well, normally, when there are lawyers involved, the enforcement mechanism is monitored by the lawyers. The judgment may even say, by such and such date, this account will be liquidated, or the judgment may say, upon signing of the judgment, these funds will be transferred. And we do it here in the office all the time, where we'll have almost like a mini closing, where we'll sign the consent for divorce, we'll sign the papers, and then there'll be funds taken out of the trust account of the law firm, and that's been held for division, and you'll get $30,000, and the other one will get $30,000, or whatever it is, and that's how it happens. But sometimes these things occur where there are triggering events that haven't occurred yet. Like, let's say we're going to each get $50,000, but it's going to come from the sale of the marital home, which hasn't happened yet. In a situation like that, the judgment may say, upon entry of the judgment, the parties shall have 30 days to put the whole house up for sale and sell it, and then proceeds after cost of sale will be split. Well, what happens if nobody does it? What do you do if your ex is supposed to put that house up for sale? He doesn't do it. Well, the remedy is you have to, unfortunately, go back to court. And you have to file a motion with the court and say, look, here's the judgment, here's what this says what we're required to do. My ex hasn't done it yet. I want the court to intervene and order the property sold. I want a receiver appointed. I want certain things to happen. And the court has a whole panoply of remedies that it can utilize in order to get you what you want. Now, the problem with that is, as you know, anytime you involve the lawyers, anytime you're going back to court, guess what you're doing? You're incurring expense. Going back to fight even a simple motion where you're 100% right and they're 100% wrong. Easily $1,500, $2,000, $2,500 in order to accomplish that. Because of the filings that have to occur, the time to do it, serving the other side, getting an order for a hearing, conducting the hearing, getting an order post-hearing, all of these things take time and they cost money. The good thing is that most of your judgments of divorce that are crafted by lawyers will say, if we have to spend money and time enforcing this, the other side's got to pay the actual attorney fees. Sometimes the judgments will say that, sometimes not. The law doesn't require a judgment to say that. And so even if it doesn't say that, many times the court will order for a non-compliant person to pay the attorney fees to the other side. So that's the good news. The bad news is it doesn't help you when you've got to start it. The expense is going to be on you, and then you'll hope to get reimbursement. That's generally how that works. If you have any questions about your particular case, though, reach out and we'll be glad to help you out.